In order for a court to find that an exclusion clause works when there has been a deliberate breach of a contract, it's needed to see clear wording. A couple of examples include Davis and Pierce, which we just spoke about, and Thomas and TNT. I'm just going to call that TNT. So it needs to be really clear wording as to whether or not deliberate breach is included. So let's talk about photo production and Securicor, which is a good example of that. So the facts in that case were that we've got photo production basically has goods that it's sent with a courier. The courier has put them into a secure storage facility. There's a security guard at the facility. It is cold, so he builds a little fire to warm his hands. Will not surprise you, photo production, basically they have film and chemicals and stuff like that that tends to be flammable. So he built a little fire, and anyway, everything burnt down and it was a bit of a disaster. So there's a contract, where is it? It says, Securicor will under no circumstances be responsible for any injurious act or default by any employee, unless such an act or default could have been foreseen and avoided by the exercise of due diligence on the part of Securicor. So, security guard, it is not part of his general work task. It wasn't in his job description, set fires. But he's a security guard. They did their due diligence. Nothing suggested that he was a pyromaniac. Nothing suggested that he would be negligent or that he wouldn't do a good job. I think probably they should have provided him with a heater. That seems to be like not an unreasonable thing, but there was nothing that would suggest that he was freezing cold at night and threatening to light fires or anything like that. They followed the terms of this clause here. So the provision says under no circumstances will they be responsible for any injurious act or default by the employee, unless that act or default could have been foreseen and avoided by the exercise of due diligence. And there was nothing that suggested that the act, which ultimately led to all of photo production stuff being ruined, could have been foreseen and avoided by the exercise of due diligence on the part of the company. So again, good example of clear wording in a particular context. So exemption clauses are to be interpreted the same way as any other term, regardless of whether a breach has occurred. The allocation of risk lies with the respondent. They are in the best position to ensure the factory. The scope of the exclusion is determined by examining the construction of the contract. The appellants had met their duty of care by not hiring negligently. On the facts, Justice Wilberforce found that the exclusion clause precluded all liability even when harm was caused intentionally. He went out of his way to disapprove the doctrine of fundamental breach of contract, which is something that you will probably explore in advanced, but which was a proposal by Lord Denning at one stage, that there should be this idea that not just is there a breach of a condition, but if there is a fundamental breach, there should be the opportunity for punitive damages. So the key principle here is that fundamental breach is a rule of construction, not a rule of law, and that freedom of contract trumps any other considerations. What about statements that are made in the lead up to making a contract? Just want to remind you of some of the stuff we've already spoken about. Firstly, we've got to work out if a statement is made in the lead up to a contract being made, is that part of the contract? Is it an express term? And we looked at cases like J.J. Savage, Dick Bentley, Van den Eschert in order to unpick that. And so really the question we're asking is a statement that's made in the lead-up, is it a term of the contract? Ultimately, when we've got a physical contract document, particularly one that states that it is the entire agreement between the parties, often we're in a situation where, and the words I've used in the past is that it's not done till it's all done. We might go backwards and forwards on certain terms and conditions, but once we negotiate and finalise, we put it down on paper that the written terms trump everything else. And Equiscorp and Glengallen Investments is a good example of that kind of scenario. But then there are circumstances where there might be a statement that's made that's a key element of a decision to enter into a contract, which itself might have been misleading or deceptive, and either isn't caught in the contract terms or informs our understanding of what the contract terms mean. And that's the kind of pre-contractual statement I want to talk about here. Let me illustrate it with an example. Actually, before I go and give you the example case, what I want to do is just give you an example of what a clause that deals with pre-contractual statements might look like. So often they're called entire agreement clauses. So this one says this agreement constitutes, so often agreement itself will be a defined term. You will often see it with a capital A for agreement, which is tends to be a shorthand that lawyers use. You will have noticed this when you looked at the Encyclopedia of Forms and Precedent. You might have noticed that there are words that you wouldn't ordinarily think of as proper nouns that had capital letters in the middle of some sentences. If you didn't notice, go back into the encyclopedia and have a look at a sample agreement. It doesn't really matter which one. And why they do that, it's kind of a shorthand. There will be a set of definitions. They're often at the beginning of the agreement, but sometimes they're at the very end in a kind of glossary form. The more modern style tends to put them at the end like an index. But law firms, they just chop and change. They all do them in their own way. So agreement itself will often be a defined term. And the term might be this capital A agreement means the document constituting the agreement, small a, used as a verb, made between the parties of the subject matter herein, or something equally ridiculous. So often other firms might use small d document as well. So I'm going to use document to not confuse us here. This document constitutes the entire agreement between the parties and supersedes and extinguishes all previous agreements, promises, assurances, warranties, representations and undertakings, conversations, promises, inferences, anything, whether written or oral, relating to the subject matter. In other words, this document contains all the promises that the parties have made to each other, and if it's not in here, then they didn't reach agreement on it, notwithstanding anything that happened before. Each party acknowledges that in entering into this agreement or signing this document, it doesn't rely on and will have no remedies in respect of any statement, representation, assurance, warranty, whether made innocently or negligently, that isn't set out in this document. Each party agrees it will have no claim for innocent or negligent misrepresentation or negligent misstatement based on any statement in this agreement. Nothing in the clause shall limit or exclude any liability for fraud. Very standard clause. But then we have Section 18 of the Australian Consumer Law. And Section 18 cannot be avoided by an exclusion clause. So the law says if you try and say that the ACL doesn't apply or Section 18 doesn't apply, then that clause will be void and potentially a whole agreement will be void. And this is because an exclusion clause in a contract can't break the nexus between the pre-contractual misleading conduct and a contract that was induced by that conduct. So promises that were made that induced somebody to entering into a contract, if they were misleading or deceptive, will still be in breach of Section 18. And to allow an exclusion clause to eliminate that would undo the benefits of Section 18. An exclusion clause cannot at common law provide protection against fraudulent misrepresentation. So the common law is clear on that, and that hence in this provision that we have in the previous one here, nothing in the clause shall limit or exclude liability for fraud. And lastly, the rule applies to Section 18 of the Australian Consumer Law, and an exclusion clause cannot defeat the operation of Section 18. So that's Section 64 from memory of the Act. So in fact, here's a slide that says it's Section 64, so it must be true. Otherwise it would be misleading or deceptive, wouldn't it? So Section 64 of the ACL provides that a term in any contract, including a collateral contract term, which attempts to exclude, restrict or modify the application of the Australian Consumer Law itself, will be void. Any term purporting to exclude, restrict or modify, or which has the effect of doing those things, the exercise of a right conferred by a provision in the ACL, or any liability for a failure to comply with a guarantee, we talked about the guarantees last week, is also void. So these are applied constrictly. Contractual terms will only be taken to exclude, restrict or modify the application of a relevant provision if they do so expressly or are inconsistent with the provisions. What else in there? There's some very specific provisions as well. So in particular, Section 29(1)M prohibits the making of a false or misleading representation concerning the existence, exclusion or effect of any condition. So remember the dry cleaning case, I think it was Curtis Dyeing and Company, but one of you can correct me if I mixed up my dry cleaning cases. The one where Mrs. Curtis says, why do I have to sign this? And it had an exclusion clause, and the person working there, apparently perfectly innocently, said, we won't compensate you if we damage the beads. But actually the clause was much broader than that. The Australian law would make the conduct, even though it was innocent, because there's no mens rea attached to the idea of misleading or deceptive. You don't need to set out to be misleading or deceptive. The test is just, was somebody misled or could they have been misled? So the act of having the shop assistant say that the term actually means it's restricted in that way would have actually been caught by the legislation in that case.
Can you just
Sorry.
A collateral contract?
Oh, the collateral contract. So a collateral contract, collateral means beside, basically. So we've talked about collateral contracts along the way in a couple of different circumstances where in order to have, and particularly in relation to privity, where we might have a contract that sits alongside. So most of the examples that we used were points where the court didn't find a collateral contract, because in order for a collateral contract to exist, it needs to be consistent with the key contract and there to enforce it. So a good example would be the I don't think I talked about it in class, I think I talked about it in the desk lecture, the Hoyts and Spencer case, where there was a lease and the lease had a term in it that said that the landlord, it was actually a sublease, and that the landlord could kick out Hoyts, the tenant, on 2 months' notice. And Hoyt said at the time, why would we, I think it was, I can't remember which way around it was actually, it might have been Hoyts as the subtenant actually, and then, as the master tenant going down, doesn't actually matter. So the landlord said, well, we'll only exercise that if our landlord kicks us out. And so the subtenant, and then subsequently they did go to kick them out, but it wasn't because their landlord had said, we're going to kick you out. And so the tenant tried to raise an argument that there would be a collateral contract, so that in fact there was a separate contract that has consideration. So the consideration here was agreement to sign the main contract on the basis of this additional promise that sat outside of the written agreement. And the court said, well, actually no, because that would be entirely inconsistent with the main contract. So it needs to be consistent, or you need to, you needed to put the limitation in the document. So again, it's one of those awkward examples where often the best examples are where it's not found. But the law recognises collateral contracts and they're existent. Another one I think I talked about in a desk lecture as well is the Shanklin Pier case, which is quite a good one. They found a collateral contract there. So Shanklin Pier is the case where I think they were called Dettol. So Dettol paints held themselves out to be really good paints for working in wet conditions. Shanklin Pier then went out to get painters to paint their pier, say that fast a number of times, and they specified in the tender document, if you want to paint our pier, you have to use Dettol paint to do it. Some painters went and they painted the pier, they did a good job, but the paint wasn't suitable. So the question was, by this stage, Shanklin Pier sued the paint company. So there's a privity issue, right, that they didn't actually buy the paint from them. But they said, well, actually, we can bring this in as a collateral contract because actually you came and told us how good your paint was. And so we effectively agreed to specify your paint. You got the benefit of this third-party contract. And you got that benefit because of some promises that you made. So yet our alternative is to get the painter to sue the painter and get the painter to sue you. But actually we don't want to do that because the painter did a good job. So we've found this collateral contract instead. What do I want to say? Look, I think I've said everything we need to say about 64 for the purposes of this class and the amount of time that we've got. But the notes are there for you to have a look at if you want to continue on. I want to talk about this case, which is actually not a particularly special case, but I just think it explains the situation quite well. It's a Queensland Supreme Court case from 2011. So it's a little bit old now. I should go and see if there's something a bit newer around. But I think it illustrates this beautifully. So Mr. Buskey, and I can't remember what his partner's name was off the top of my head, they wanted to purchase an off-the-plan property on the Gold Coast, basically. And so in that lakes area in the Gold Coast, so an off-the-plan property, effectively what this means is that the building hadn't been built yet. They went to the developer, they've seen some plans, they've gone and seen a display suite, it's all looked great. They've gone and actually looked at a number of properties, but the thing that was really important to them is they wanted to get really uninterrupted views. So this time they've gone down to, so there's a sales suite at the base of the property. This is actually a picture on the slide here of the development when it was finished, so it's very Queensland, very shiny, right? Let's be kind to we'll talk about Quexit some other time. Hi to those of you in OUA land who are in Queensland, you can explain yourselves later. So there's basically like a display setting down the bottom. It's where you could go in. It's probably made out of containers or something, I don't know, but you can go and stand in a little apartment and see what it would look like and imagine your own furniture there. And so these guys have gone in there and said, yeah, this is great, we love it, but it's really important to us that we have uninterrupted views. So the salesman has then taken them to the building next door and taken them up to, I think it was the 5th floor, and they were looking at buying something on the 7th floor. They've gone in and they've looked at what the views are, and he's basically said, well, imagine this just a little bit higher up and a little bit to the left. That's me paraphrasing. They may not have been the exact words that he used. So, however, the developer, unbeknown to the sales agent, has basically already started the process of building another building right in front of the one that they're trying to sell apartments in right now. Now, the way it works, they use so they've basically subcontracted with a real estate agent firm who's just got somebody out there all the time doing whatever they do. They haven't even told them about it. And again, this is pretty common sales practice. You don't want to start building a new building until you've filled the one that you're building now. Because, well, I assume it's like actually people want the high floors or the north facing or whatever it is that they want. And so if they think another building is going up shortly, then they'll wait for that one rather than, and it's costing you money, you know, you're not actually getting all of the money until you've built your building. So they will stream the release. So they don't even want to tell the sales agents anything because they want them to sell everything in that building. So anyway, the Buskies are really excited about this apartment. They go down and they decide that they're going to make an offer and they go and fill out a contract for sale. So, which includes them doing, so they spend a couple of hours in their display suite doing things like choosing carpet and picking the colour of their tiles and door handles and doing whatever you do if you're building a shiny apartment in Queensland. But the apartment does not mention, or the contract does not mention, uninterrupted views. It then contains this, it's quite hard to read, it comes directly from the case, clause 10.6, so not right at the beginning of the contract, but this clause which has the heading entire contract, no representations. I'm going to read some of it to you because I think otherwise it's a bit hard. So the buyer acknowledges and agrees that no representations of the agent or the seller were supplied or made to the buyer with the intention or knowledge that it would be relied upon by the buyer. So in other words, we didn't tell you anything and expect you to rely on it. B, no representations have been in fact relied on the buyer unless they are specifically contained in this contract or the disclosure statement. So even if A is wrong, you actually haven't relied on anything unless it's in this contract or we've added it in somewhere else. So put the onus on the buyer to do that. Before the buyer entered into this contract, it satisfied itself from its own independent inquiries as to the value of the property. The buyer has relied on its own judgment in purchasing the property on the terms contained in the contract. Terms of this contract and the disclosure statement are the entire agreement between the buyer and the seller despite any representations before the buyer signed the contract. To the extent that there were any representations before the buyer signed the contract, the terms of this contract supersede them. Without limitation, no representations have been given that the property is or will remain fit, suitable or adequate for all or any of the purposes the buyer wishes to use the property for. And to the maximum extent permitted by law, all representations or provisions implied by law relating to fitness, suitability or adequacy of the property do not apply to this contract or the property. I think that's a pretty good clause myself. I did a little bit of translation at the beginning. I didn't really need to. I was just like being nice. I think it's a pretty solid clause. Of course, when the Buskies found out that a building was going up right in front of the building that they had just bought in, they said, yeah, we'd like our deposit back, we're not going ahead. And the developer sued them. They said, no, you entered into a contract, we need the balance of the purchase price.
Oh, sorry, why did the developer sue when they were asking for their money back?
The developer, yeah, because the buyer has basically put down a deposit and now doesn't want to go ahead, wants their money back. Instead, the developer's saying, no, you've got more payments to make. We need the balance of the payments here. So I mean, Busky could have sued the other way, but but that's where it is. So the question before the court became largely, does this clause protect the developer? Was the act of taking the Buskies up onto the 5th floor and showing them the view an act that, is that a representation that gets caught into the contract? And even if it does this clause actually operate to limit the impact that it has? The short answer is the developer could not rely on this clause. So they said, no, Clause 18 of the Australian Consumer Law says, thou shalt not in trade or commerce do stuff this misleads or deceives people. Doesn't matter that you didn't do it on purpose, and we will take into account the fact that you may well have, if you do this and you induce somebody to get into a contract, you can't then rely on the contract to undo that behaviour. So again, it's actually not a particularly radical decision. Like it didn't go to the High Court subsequently. There are other very similar decisions around. I just think it's a good example of, at one level, so somebody like me who I like that clause. I would have thought that clause would do quite well actually, but it just reminds us that if you are going to do things to induce customers to come into a contract, and those things have the potential to be misleading or deceptive, then an exclusion or an entire agreement clause is not going to protect you. Now, some of the stuff I didn't tell you in my little outline of the case was that there was also quite a lot of evidence given to the extent that the developer went to hide from the sales staff that they were going to do this other development as well. And so part of this is also, I think, a court saying, if you're going to, there are consequences for your sales strategies, and sales strategies that have that potential impact of misleading or deceiving people will have consequences. But they do sort of fall out in a whole lot of ways, and so they demonstrate in compliance programs and in the way that our clients and customers deal with people that exaggerating the capabilities during a tender process or a pre-sales process, even outside of a direct consumer contract, can have ramifications, and an entire agreement clause may not protect you. Question I often get asked at this point when I talk about this case is, well, did they get legal advice? They did get legal advice. So why didn't their lawyer pick up that the views were important to them? My guess is that the lawyer didn't ask the question. The thing is often too, and lawyers can be quite lazy with this stuff, and it happens, if I...
subjective also,
yeah.
Like what does view mean and how much of the view and...
Well, given that something had actually happened to show them that, you know, this is what it's going to be like.
Yeah.
There's nothing going to be between you and the sanctuary estate or whatever it was called. I think they could actually tie it in there. But the thing is, I think too, often what happens is clients give a lawyer a contract and say, is this okay? And of course the lawyer doesn't necessarily know what it is that they're trying to do. And if I've said it once, I've said it a million times, contract is a verb as well as a noun. And sometimes we actually have to remember, you know, the immortal words from that movie Philadelphia, explain it to me like I'm a 3-year-old. Actually asking our client, before I even look at the document, tell me what's important to you. Tell me what you think you've agreed. So I can work out whether it matches. And sometimes actually just, because it is a very human thing. And lawyers, we're not overly known for our empathy or sitting in there and trying to understand what our clients are doing. But at the end of the day, for my money, that's the most interesting part of the job. You know, I've done this job for a really long time because I'm genuinely interested in how people do business and what they agree and how they make their businesses happen. And you know, I'm wearing a medal today, so I can big note myself. At the end of the day, I think one of the reasons I'm good at it is because I am trying to reconcile the verb and the noun. And so that's a little piece of life advice for you. We're not going to really do this here because we're going to run out of time. So what's really important here is to say, to just be really clear that exclusion clauses really are no longer have any real relevance, particularly in consumer contracts, because of the way the ACL works. Yes, I've actually just added this in because I think this is quite a good quote from a similar case that was in the High Court. Neither the inclusion of an entire agreement clause in an agreement nor the inclusion of a provision expressly denying reliance upon pre-contractual representations will necessarily prevent the provision of misleading information before a contract was made, constituting a contravention of the rules that say you can't mislead or deceive. Whether contract is misleading or deceptive is a question of fact, to be decided by reference to all of the relevant circumstances, of which the terms of the contract are only one. So an exclusion clause will not limit that evidence getting in. So, in the very limited amount of time I have left, I just want to talk to you very quickly about unfair contract terms. So, the important things to know here are that the unfair contract regime applies in relation to a certain type of contract. Consumer contracts that are provided in a standard form. So let's think of those for the moment as take it or leave it contracts. Examples might include things like your telephone contract, your gas and electricity contracts, your gym membership, the terms and conditions offered by the university for your study. They're standard forms, they're generally not negotiable. You don't have to sign up, but your options are take it or leave it. Since November 2016, these rules have also applied to small businesses. So, Section 23 of the Australian Consumer Law says that a standard form contract can't contain terms that cause a significant imbalance in consumers' rights as opposed to a business rights, are not reasonably necessary to protect the business's interests, and cause detriment to the consumer. So it's not saying terms in standard form contracts have to be fair. It's saying terms cannot be unfair in these three ways. Standard form contract will usually be one that's offered on a take it or leave it basis, where a customer will be given the same contract and won't be able to negotiate terms. Some of the terms included in standard form consumer contracts are not subject to unfair contract terms. They include terms that define the main subject matter of a consumer contract. So, let's say, let's think about an example here, maybe I'm going to use the gym membership example. In fact, it might not be at all fair to, in a general sense, to pitch certain type of gym memberships to certain demographic of the population. So, in fact, it might be that, the health benefits of hot yoga are completely inappropriate for fattish middle-aged women of my standing. But it's a hot yoga contract. That's what the subject matter is. It doesn't need to be fair, good for you, anything like that. That's just what the contract is. So we don't have to exclude that. Upfront price payable under the contract. The price itself doesn't have to be fair. There are terms that talk about the total price or the way that prices are calculated. They might need to be fair, but an upfront price, the price itself doesn't have to be fair. Or other terms that are required or expressly permitted under the law. So there are some types of contract that always have to have particular terms in them. So, for example, a door-to-door sales contract needs to have a 7-day cooling off period in it. In fact, that might be really unfair in a particular circumstance. I can't think of one off the top of my head, but it could be unfair, in fact, to the provider. Door-to-door sales of ice cream, where we hand over the ice cream to people who do not have refrigeration, and they've got a 7-day cooling off period, and they can just return the melted ice cream. It might be unfair. bad example, but best one I can think of. Doesn't matter. If it's required by the law to have a 7-day cooling off period, cooling off is a really bad example to use with ice cream, but there you go. Section 28 says that a company constitutions, contracts relating to shipping and towage are not counted. So technically, the constitution of a company is a contract between the company and its members. It can have unfair terms in it, even though it's a standard form contract, as far as the ACL is concerned. Why shipping and towage are not counted, I don't know. Other than, I guess there's the stevedoring sort of example where it's often you need to have just a one supplier. It's an unusual thing, but I think probably Lindsay Fox paid money to whoever was running for an election at the time, and that's where it comes from, I guess. Yeah, so it's not the role of the legislation to say what you can enter into contracts about. Consideration needs to be sufficient, it doesn't need to be adequate, and there's legislative efficacy in the last of those options. Now also applies to small business. That means that you've got to look at definitions. What is a small business? Basically 3 points. Goods or services, or the sale or grant of an interest in land. At least one of the parties is a small business, so employs less than 20 people, including casual employees employed on a regular and systematic basis, and that the upfront payment is no more than $300,000, or if the contract is going for more than 12 months, no more than $1 million. If a contract is varied after that date, then it gets caught by the regime from that point onwards. So, in a nutshell, if within the circumstances described by the law a term is unfair, that term will be void. If the term can be severed and the remainder of the contract continues, then the remainder of the contract will continue to bind the parties. The court needs to consider certain factors when determining whether a contract is a standard form contract and whether or not the contract itself is unfair. The legislation provides the onus of proving each of those on different parties. So, for example, if you bring an action stating the standard form agreement is unfair, then the onus will be on the party providing the contract to demonstrate that it's not a standard form. And they are in the best place to do that because you don't know the other people that they contract with. If a term is unfair, to be unfair, it needs to satisfy 3 tests, which relate to an imbalance in the parties' rights, the protection of legitimate interests, and the detriments. We'll go to those next. And the legislation itself gives examples. It's a nice, plain English, easy to read legislation, and I would strongly recommend that you have a look at it. And as an aside, in the databases that are available through the library, they include Miller's, which might not be as... I'm pretty sure it's online, but even if it's not, there are hard copies that are available relatively easy. So Miller's annotated competition and consumer law, basically each provision of the law comes with list of cases that have been decided, list of information, makes it much more accessible if you are not reading, if you're not getting it on a first reading. So what is the effect of unfairness in this situation? Need to have the elements. So, standard form contract, that's dealt with section 27, we'll talk about that in a second. We need it to be a consumer contract or a small business contract. So that's a contract under which an individual acquires goods, services or an interest in land predominantly for personal, domestic or household use or consumption, or in a small business context. Predominantly means, in this, it's been found to mean that it's regularly. It's kind of a very broad use. The term itself needs to be unfair, and then it'll be void. So we've talked about what void terms are before, and let's talk about what it means to be unfair now. So 3 tests, as I mentioned before: significant imbalance. So that means the person bringing a claim, now that might be the ACCC, by the way, might not just be a person subject to the contract, on the balance of probability that the terms are not transparent, they're not automatic, on the balance of probabilities that there is a significant imbalance. The fact that a term is not necessarily transparent doesn't make it automatically unfair, and there are some terms that are transparent that in fact will be unfair themselves. It doesn't rely on any concept of good faith. It relies on this idea of unfairness. The term must be not reasonably necessary to protect the legitimate interests of the advantaged party. So again, think back, a good way of thinking about this could be that Pierce parking case. At one level, it seems your employee was negligent. That term shouldn't protect you when my car gets stolen. But the court found in a common law sense there that that term was actually reasonably necessary to protect the legitimate interests of the owner of the car park. And if that clause was dealt with in a different way, then the costs for insurance for the car park would go right up, everybody's costs would go up. So there's a rebuttable presumption here that a term is not reasonably necessary. So again, the onus, that means the onus goes to the person who has the benefit of the term to demonstrate that in fact it is reasonably necessary. So if I use Pierce parking, and this is not, Pierce parking is 1950 something, so clearly this legislation was not relevant then, but if they were to face an argument that the clause excluding their liability was unfair, they would be arguing that it's not reasonable. It was there reasonably to protect their interess. We have an inadequate explanation, which is where I'm going to today as we're getting tighter and tighter, an inadequate explanation of a complex or an onerous term. The legislation says that that itself might suggest that the term is unnecessary. Thirdly, the term would cause detriment if it were relied on. So that's the essence of the unfairness. The likelihood of detriment is not enough. It needs to actually cause detriment. And detriment, though, it doesn't need to be financial. It could be pain and suffering of some other kind. The court may take into account any matters that it thinks is relevant. The court must, however, at least consider the extent to which the term is transparent. So let's talk a little bit about transparency. A term of a consumer contract will be transparent if all of the following things exist. It's expressed in reasonably plain language. It's legible. It's presented clearly, and it's readily available to any party affected by the term. In the lead up to this legislation coming in, so in the, well, actually probably even earlier than this, I'm thinking sort of the late 90s, early noughties, it used to be almost impossible to work out what contract a client had for the provision of internet and telephone services with Telstra in particular. I'm going to name them because what do you know? But because they would supply their standard terms on the internet all the time, and there was nothing at the time that actually required them to have kind of version control. So if I enter into a contract on a particular day, there are terms that are on the website. Unless I actually go and download them and date stamp them in some way, I have absolutely no way of working out what they were. The number of actions in the end that I had over that time, where in the end Telstra would just end up having to just give up because they couldn't work out what they were either. But again, these kind of they were sales practices. And we've got to remember, organisations many of them are very big. They're dealing with their businesses in particular ways. And so there's a lot of discipline has been applied by this legislation to require contracts to be in plain language. Transparency is only one of the factors which a court needs to consider. Just because a highly skilled lawyer can find or contrive some equivocation in a word, that does not make the language lacking in plainness or intelligibility. So I'm going to finish at this point, and then I may actually end up having to put a little bit more online for you, as it seems, because I really have ambitions that are beyond my capabilities to get through materials. It is worth having a look at Section 25 because the legislation itself provides examples, statutory guidance as to what unfair might look like, but it's a non-exhaustive list. So I think that's quite important to you. Can I just have a quick look and just see if there's anything in particular that I need to bring to your attention? Yeah, I will. It is worth understanding that these provisions can be enforced by the regulator as well as by private persons who are impacted by them. And Section 251 sets out what the implications of that are. Because the first step is a court needs to declare that a term is unfair. And basically, the ACCC can just go and get that order. They can do it themselves or an individual can get it. But at that first stage, so the other thing that you can do under the provisions is you can get an injunction to prevent the use of the term. That goes hand in glove with the declaration. The next thing is damages. So there are no damages on the first round. It's just void. That term is void. So you can't, there's no actual compensation for an unfair term. You can get a declaration, you can get it removed. If the contract can continue without the clause, it continues. If it can't, then the contract itself is terminated. What have I got there? I hate it when I have got language that's too small for me to read. So the question, this is why we're talking about no damages here. So Section 15 provides that conduct consisting merely of voiding an unfair term will not constitute a contravention. So the next question that we ask ourselves is, what happens if the provider of a term continues to seek to rely on that term after this declaration is made that the term is unfair or an injunction has been issued? And basically, both the ACCC and a person against whom that term is sought to be enforced after that declaration has been made, even if it's been made by somebody else, in relation to somebody else, can get damages then. And in order to redress loss or damage to a non-party consumer, clearly that can only apply if the ACCC bring the action. It can't, there's no you're either a party and you get damages, or you're a non-party and you need the ACCC to help you. So I just thought that was worth, I've tried to in one slide pull those ideas together. But we are at 8:30. We will have a shoot this Sunday night. I will offer some other shoots on the weekend times, but I do need you guys to do some thinking about when and how you want to engage with me. And I'll hang around for a bit if there are any more questions. And you at home, please feel free to contact me. Thanks so much.